3, 2, 1, go. The present appeals have been filed challenging the order of the reference court dated 20 May 1980. Learned Counsel for Appellants submits that the land in question, which is subject matter of the present appeals, was acquired between the years 1965 to 1969. Subsequently, pursuant thereto, award was made by the Land and Building Department for the purposes of acquisition of the said land. It is submitted that there were three sets of claimants for claiming compensation for the acquired land, with first Gram Sabha, which raised its claim on the basis that it was a waste land. Second, owners of the land and their transferees, and third, Gulab Sundari, who claimed to be the Bhumidar of the land in question, and her transferees. It is submitted that the reference court, by order dated 28 May 1980, rejected the claim of Gulab Sundari, thereby holding that the land in question was not a waste land. Further on, it was held that the owners and the transferees, as well as Gulab Sundari and her transferees, were entitled to compensation for the acquisition of the land. Against the aforesaid judgment dated 28 May 1980, passed by the reference court, 6 regular first appeals RFAs came to be filed before this court. 4 sets of appeals being RFA 309 1980, RFA 310 1980, RFA 356 1980, and RFA 357 1980 were filed by the persons who claimed to be owners of the acquired land and who had wrongly been denied compensation by this court. 2 sets of RFAs were filed by Gram Sabha, viz. RFA 340 1980 and RFA 341 1980. By judgment dated 26 February 1991, this court dismissed the appeals filed on behalf of Gram Sabha on merits on the ground of res judicata, thereby holding that the land in question was not waste land. The 4 RFAs filed by the persons who alleged to be the owners of acquired land were dismissed on technicality of abatement, that the legal heirs were not impleaded after expiry of the original appellants. It is to be noted that after dismissal of appeals by this court, White order dated 26 February 1991, subsequently Delhi Development Authority DDA filed an application for impleadment on 23 April 1991. Since the appeals had already been dismissed by this court, by order dated 9 August 1991, the division bench of this court informed the DDA with respect to the disposal of the appeals already. Thus, the fact remains that DDA was never a party in the said RFAs. Against the aforesaid judgment dated 26 February 1991, passed by this court, civil appeals were preferred before the Honorable Supreme Court. By judgment dated 17 December 2002, Honorable Supreme Court allowed the said civil appeals, thereby remanding back the matters to this court to adjudicate the RFAs by hearing the LRs of the deceased appellants. It is submitted on behalf of the appellants that from 1991 till 2002, when the Supreme Court disposed of the civil appeals, the DDA was never in the picture. Stop.